Here we go. Hello, everyone. My name is Giuseppe Martinico. I'm a full professor of comparative public law at Scuola Superiore Sant'Anna in Pisa, and one of the directors of the Sant'Anna Legal Studies program, together with Giacomo Delle Donne and Filippo Fontanelli. Today, I'm very glad to share this book launch devoted to the latest monograph of Professor Angioletta Sperti, Constitutional Court. Let me show the cover properly. The Constitutional Court's Media and Public Opinion, published by Art Publishing in 2023. Angioletta is a full professor of comparative public law at the University of Pisa, where she also teaches comparative constitutional law. Her main research interests include the constitutional justice, human rights, and non-discrimination law, the sources of law in a comparative perspective. She's author of 5 monographs on constitutional justice, the presidential accountability, dialogue among constitutional courts on LGBT rights, and on the advancement of LGBT rights. I want to mention here her book, The Constitutional Courts, Gay Rights and Sexual Orientation Equality, published by Art in 2017. We will discuss her latest book with the 2 top discussants and 2 friends, among other things, namely Maartje De Visser and Giorgio Repetto. Maartje is a professor of law at the Singapore Management University. Her research is centered around the subject of constitutional engagements by courts and other state actors. She also has an interest in the local application of global constitutional norms and comparative methodology. She has published widely on this topic in top journals. I want to just mention articles published in the International Journal of Constitutional Law, Global Constitutionalism, the American Journal of Comparative Law, and the Asian Journal of Law and Society. She has co-edited 6 books and contributed with chapters to more than 30 edited volumes. She's, among other things, the founding co-chair of the Singapore chapter of Icon Society and a member of the Icon Society Council. Giorgio Repetto is a professor of constitutional law at the Faculty of Law of the University of Perugia, where he holds the chair of European constitutional law. He's also law clerk at the Italian Constitutional Court. He's author of a very important book on the role played by comparative arguments in the case law of the European courts of Strasbourg and Luxembourg. And he has also published in top journals. I want to just mention the European Constitutional Law Review and the German Law Journal, among others. He also edited an important volume on the constitutional relevance of the European Convention of Human Rights in Domestic and European Law, a book which was published by Intersentia. His research interest cover theory and practice of fundamental rights, constitutional adjudication in European and comparative law, and constitutional theory. So we have a stellar panel, and I'm very happy about that. So thanks so much for accepting our invitation. According to the rules of the game, Angioletta is going to speak first. She will present a bit the main ideas behind the book, and then we will give the floor to Maartje and Giorgio for their comments before opening the Q&A session. Having said that, thanks indeed, Angioletta. Ready where you are.
Thank you. Thank you. First of all, I would like to express my gratitude to Giuseppe for organizing this event today, and the speakers who have accepted the invitation, and all of you are here today to discuss with me about this book. So thank you very much. I would like to explain how the idea came about and to summarize some of the key findings of my work. So I started this research in 2019 when Giuseppe, Giorgio, and I were invited to report on the latest developments in Italian constitutional justice at a conference held in Turin. And that conference was a wonderful opportunity for me to discuss with many colleagues and friends, but it also gave me the opportunity to start exploring a topic that at that time seemed to be very innovative, which was attracting great attention, in particular the relationship of the Italian Constitutional Court with public opinion. The Italian Constitutional Court in 2017 had hired a new head of communication who was, for the first time, a professional journalist. The court had revamped its website, launched a lot of initiatives to know and be known, as the former president of the court said. So this increased and proactive engagement with the public was attracting the attention of scholars and was raising a large debate on the consequences of the proactive communication of the court in terms, of course, impartiality, of course, legitimacy. So my first topic, my first field of research was this new relationship of the Italian Constitutional Court with public opinion and its consequences. I also explored whether the Italian Constitutional Court was alone in this new course of communication, and I realized that there were many points of contact with other jurisdictions, with other constitutional and Supreme Courts. And it was also very interesting noting that all the courts have developed similar strategies, similar initiatives autonomously, independently from each other. So I would like to stress that I consider in this book public opinion as an output of the court. That is, public opinion as the target of court's communication. And as I clarify in the book, the relationship of courts with public opinion has been mostly analyzed in the past in the opposite perspective. The public opinion as an input of the courts. So in a few words, in the past, public opinion was mostly taken into consideration in terms of the influence that public opinion has on the court. So how courts take into consideration the change in moods in public opinion, how at the same time courts contribute to support some social changes, to forge constitutional arguments. So compared to this perspective, my perspective is the opposite. I look at public opinion as the output of course. I take into consideration how courts speak to the public and of course which are the consequences of this proactive and direct engagement of the courts with public opinion. A second point I would like to stress is that in the past, public opinion has been mostly studied, analyzed in its relationship with the political branches, with the political bodies. Of course, this is quite intuitive because public opinion is considered the foundation of democracy. So it has been analyzed in connection with the representative states. So in this book, instead, I address the relationship of the courts, non-political bodies with public opinion. So I question, as I will say, some of the conclusions that have been reached by scholars who have instead addressed public opinion from a different perspective. So as I proceeded with my research, I started to investigate also the relationships of courts with the media, with journalists. And I enlarged my field of investigation to communication studies because I think I emphasize in the book that for a proper understanding of the relationships of courts with public opinion, it's also necessary to pay attention to explain when cases become newsworthy, how cases are reported, which are the difficulties that both journalists and courts face when it comes to reporting on difficult topics such as the judgments, the court's judgments. So in Italy, but not only in Italy, in all the jurisdictions I have addressed and I take into consideration in the book, this relationship between journalists and courts has been described as love and hate relationship. In Canada, for instance, the Supreme Court has stressed, of course, the importance of the press. All courts are aware, of course, of the importance that the press plays in their communication, but nonetheless, there is an ambiguous relationship with journalists, with the press, because this is due, of course, to the difficulties of reporting, to the circumstances sometimes reporting can be misleading, that sometimes also reporting can be inaccurate. So there is an ambiguous relationship, and love and hate relationship that I stress in the book. So there are two directions of my investigation, which are narrowly intertwined in the book. The dimension of the relationship, of course, with public opinion and the relationship, of course, with the media. I try to address the challenges raised by both these two dimensions of institutional communication, of course. And the first one, the relationship of the courts with public opinion, raises challenges and also criticism in terms of course impartiality, in terms of course legitimacy. It has been said that by pursuing more proximity to the public, courts are also losing their traditional distance from citizens. They are losing their aura of impartiality. And there are, of course, some differences among the jurisdictions I address in the book. But despite the many differences in terms of the organization of the judiciary, in the features of the judicial review legislation, despite the differences also in the models of journalism, when it comes to the strategies, to the solutions that courts have adopted to communicate with public opinion, the landscape is pretty much the same. Instead, in terms of criticism, they are influenced by the context. Criticism is more influenced by the political landscape, by, for instance, the role of the courts and constitutional system. In the UK, to mention an example, where the proximity of the UK Supreme Court was due to the novelty of the Supreme Court itself, most of the objections are related to the fear that the court would not be able to convey an effective message, that the message can be misleading. There is, of course, also the fear that the court can change its role in the system of government, but there are also more practical concerns. Instead, in Italy, the issue of the relationship of the Italian Constitutional Court with public opinion has become almost the object of an academic obsession, as I write in the book. So its scholarship have raised criticism, saying that the court is changing its approach with the people, it's selecting a public, is engaging in dialogue with the public in a way which is quite similar to the approach adopted by political branches. So I come now to some key findings of my book, some conclusions. It's difficult to summarize the ideas, but I will summarize the three main points, main arguments I expound in the book. My first point is that it is reductive to read the transformation of the institutional communication of the courts, just as the effect, just as the consequence of the transformations that have affected public communication in the last decades. Of course, the spread of the internet and associated technologies was a trigger. I do not deny this. But there are also, the landscape is much more complicated. It's quite, the issue is more complex. I argue in the book that also the court's awareness to be the least known among public institutions has played a relevant role in their decision to approach the citizens in a more proactive, a more dialogic way. But at the same time, also populism, the risks of democratic backsliding have increased. The need of the court to know and be known by the people. Courts feel to have a duty to contribute, to support constitutional value, to counter democratic backsliding. So there are some pages in the book in which I clarified that most of the courts described this new approach as a duty, as a social duty. And this is a word that has been often stressed by the heads of the communication of the course I had the opportunity to interview when I was working on the book. So they see this approach as the answer to a social need at the same time. So in all this landscape, communication is crucial. It's not only a means, in a few words, to keep up with the times, but it's also a means to support democracy. The second point I address in the book is the relationship of courts with public opinion. What's public opinion for the courts? I argue in the book that most of the criticism raised against the proximity of courts to citizens, to public opinion, is influenced by constitutional and political theories that since the 17th century in England and the 18th century in continental Europe stress the role that public opinion plays in a democracy, the role of public opinion in representative states. Scholars agree that a condition for forming public opinion, there is no general consensus on the notion of public opinion among sociologists or political theory scholars, but scholars agree that a condition for forming public opinion is that the consensus around the opinion should also be able to exert influence. So issues of consensus bring to the fore also the idea of influence. There is this connection. And so in the book, I refer to this idea of consensus, and I stress that consensus is different from consent. Consent implies approval, implies support. Instead, public opinion is based on consensus, on a shared opinion, as the origin of the word say, on a common understanding, and therefore on dialogue, on a more interactive engagement with public opinion. So I argue in the book that most of the criticism originates from this ambiguous notion of public opinion, its ambiguous relationship with consent, with consensus, and its common understanding in relationship with political bodies. So consensus that courts pursue cannot be considered equal to political support. I stress this definition because I argue that, of course, courts do stimulate support. They do stimulate consent. They do stimulate consensus. I'm sorry, and they do pursue legitimacy. But it's a different kind of consent. It's not support for a partisan position. It's not support which is alternative or consistent with a position taken by political bodies. It's instead more related to the search for legitimacy. And it's a search for legitimacy which is based on formal ground and substantial grounds. Formal grounds are, for instance, the supremacy of the Constitution. Substantial grounds are instead history, legal discourse, or the rigor of logic, the coherence of course reasoning, transparency, publicity, which are key values in constitutional law. So their overall role, I can say. So, but at the same time, it's also the search for legitimacy is also related to promotion of constitutional principle, to promotion of constitutional values in order, as I said, to counter democratic backsliding. So I argue that there is no novelty in this approach. Hamilton said that constitutional courts have neither force nor will, but merely judgment. So courts have always pursued this search of legitimacy, this consensus. They always have engaged in a relationship with citizens. Of course, now the landscape has changed. This approach has become more widespread. The solutions which have been adopted are very diverse. There are a lot of ideas which have been put in place, but we should be also taking into account that this approach is no novelty, and it is related to the traditional trait of constitutional courts as political and judicial hybrid. The last point, and my conclusion, is that I do not deny the risks and challenges of this approach. I'm very critical towards some solutions which have been adopted. For instance, I don't have time to summarize all the objections I raise in the book, but for instance, I'm very critical towards the anticipatory press releases that the Constitutional Court of Italy frequently uses. I also quite skeptical towards the use of social media, which I think they're not very suitable to the court's role. We can address this topic later if there is the chance to do that. I also say that the large media exposure of justices is a reason of concern. So I raise some concern. I do not deny the risks and challenges of this new path of communication. I conclude in the book that recent developments in communication made it essential for the justices and for the court as a whole to contribute to raising awareness of the institution of which they are members, of its role in citizens' lives. So it's important to spread the constitutional culture, but nonetheless, justices should always be ambassadors of the words of the courts, not of their personal message. And so courts do have to build consensus in this landscape, but this consensus should not be consensus on individual issues, on each of their judgments in terms which are quite similar to the search of political support. They must pursue instead support, consensus for their overall function and the constitution of which they are privileged interpreters. So this goal should also guide each justice. So the new approach calls the court to a new responsibility to find a new balance between secrecy and transparency, between openness and seclusion. And they also have to pay attention to preserve their own role and legitimacy. Thank you.
Thanks indeed, Angioletta, for this very interesting thought to your book. And now it is time to give the floor to Professor Maartje De Visser. I forgot to mention that Maartje is also the author of what with Giacomo we, call it the Bible, the Constitutional Review in Europe, per comparative analysis, the best book, on planet Earth, at least, I don't know elsewhere, I don't know on Mars, but there is a fantastic book. And so thanks indeed, Maartje, for being with us. Where you are.
Well, let me start by repaying that compliment and saying thank you so much, Giuseppe, for putting this up, for inviting me to be a part of this. It's always a delight to be included in the Italian circle of scholarship. So I feel very privileged that I'm now part of a club that I saw in South Africa is quite a strong community. And I would just like to say, it's just such a genuine pleasure to be here and to be part of a panel to discuss a book that addresses a very topical phenomenon that also intersects very closely with my own research interest in the notion of constitutional literacy, as I call it, and the role that courts can play in cultivating such literacy, including among the general public. Now, the book does a lot of fantastic work. So if you haven't read it yet, then I would suggest you go out and you buy yourself a copy. You can start reading it this evening if you get the e-copy that I'm sure is available. But what I like in particular about the book is that it's very insightful, because what it does is that it unveils just how wide-ranging and creative a selection of Western courts are in making their work known to external audiences. So it does so from a comparative perspective, and it puts into perspective activities that often are under the radar. So I think that that's already a very important contribution that the book makes. Secondly, the book boasts a strong interdisciplinary dimension, and it draws on, and we heard Angioletta say that, it draws on fields from constitutional theory to communication studies, and it thereby is able to offer an holistic account of the analysis of the activities under study. So I think it's very helpful to have this kind of interdisciplinary research. Now, in my intervention today, I hope to do the following. I hope to identify 2 lessons that the book offers, provide 2 sets of observations on its analytical framework, and then end with 2 questions that hopefully can inform a future research agenda. So in terms of the lessons, the first, I think, from a methodological perspective, is that it is no longer sufficient, if ever it was, to limit yourself to the study of classic legal materials. So the Constitution, legislation pertaining to the court, rules of procedure or judgment, when we try to understand and evaluate the functioning of courts. A realistic approach demands that all the content that they produce, from press releases to podcasts and all the other activities that they engage in, is systematically taken into account as well. This matters, I think, because it sheds more light on the self-understanding of courts and their conception of who is or who are their audiences of their activities, be it adjudicatory activities or otherwise. Now, in a similar vein, we should approach studies of highest courts in particular in a manner that puts their relations with other actors at the center. So we should have this turn to a relational approach, as Marta Cartabia, a former president of the Italian Constitutional Court, has also referred to in an editorial for the International Journal of Constitutional Law. Now, these relationships should not be conceived only in interinstitutional terms, so in the relationship with the political branches of government or with other courts, be it either within or outside the domestic legal order. We should also include social relations, including those with ordinary individuals. These social relations have evolved rapidly over the past year, as the book, I think, very nicely and accurately chronicles, and they deserve greater attention. This would, I believe, at least require a map of the amount and kind of judicial activities designated to reach ordinary individuals, a discussion of the impact thereof on those individuals as well as on the court's authority, and an assessment of whether and how the strengthening of the social relationship is shaping judicial interactions with other bodies, so how it has a multiplying effect in other relationships as well. The second lesson that I think the book offers is, normatively speaking, that it prompts us to reflect on the contemporary expectations that we should have when it comes to courts' adherence to classic rule of law values as far as their own functioning is concerned. So often we talk about courts upholding the rule of law and upholding democracy, but I think that when it comes to the functioning of the courts themselves, there is an important rule of law dimension as well. And for our purposes, this notably refers to notions of accessibility and transparency. And transparency is really one of the leitmotifs of the book. Now, assuming that we desire that judicial work is intelligible to ordinary individuals, including so that these ordinary individuals know what is expected of them, it no longer seems sufficient for courts to convey knowledge exclusively or mainly through their judgments. In particular, the information that courts can, and I would say should provide, usefully extends beyond conveying the meaning of judgments to disseminating knowledge about the mission of their institution and their importance within the legal order. And this means that we may be required to rethink what constitutes socially appropriate and legitimate judicial conduct beyond the classic paradigm of thinking of judges as performing only adjudicatory activities. While we need to bear in mind the importance of safeguarding judicial impartiality and judicial independence. So these, I think, are two lessons that the book offers us, one methodological and one normative. And I hope that all of us take these lessons to heart as we continue our study of the courts that we are most interested in. Let me then move on to two observations that I would like to make. First, the book states that the evolution, and here I quote, from the creation of press offices to public hearings across the country, is qualified as the progressive path from monologue to dialogue, in particular from transparency and one-way information of the court's judicial and extrajudicial activities to direct communication and dialogue with citizens and public opinion. Now, here I should admit that I have some reservations regarding the appropriateness of the use of the notion of dialogue as an analytical or classificatory tool. Now, let me be clear here, courts clearly have done more than just engage in a monologue. I think that much we can all accept. It's gone beyond simply putting information out there and hoping something sticks. To be clear also, dialogue is a very popular notion. We see it in constitutional law as a way to describe the interactions between courts and legislatures, as we've heard in, for instance, Canada, the United Kingdom, or New Zealand, and beyond. It's also very popular in European Union law, when we talk about the relationship between national courts and the Court of Justice of the European Union. And I think that we like the notion of dialogue because its appeal is very clear. It evokes the imagery of a series of exchanges, usually between two participants or speakers, who respond to each other's utterances in a meaningful and focused manner, ideally with a view to arriving at a conclusion that is palatable to both sides. Now, the question I have is whether this metaphor, because I think that is what we are dealing with, a metaphor, accurately represents what is actually going on. Now, courts, to be fair, are increasingly embracing initiatives that envisage, at least from their side, more than a unidirectional mode of contact. But the real-life opportunities for the public to respond to or interact with the court remain limited. So if we think about visiting the website, or seeing the court in action outside its usual venue, or liking a Facebook post, or even writing a comment on Instagram. These require some initiative or action on the part of the individual. But can we truly say that these give rise to there being a successive sequence of utterances, an exchange between the court and the individual or the public at large? Now, one possible exception here, I would say, are the journeys that the Italian Constitutional Court has taken through Italy, where we really see conversations of sorts between the judges and inmates, or judges and school students. But these are by no means widespread in other jurisdictions, nor offer interactions with large segments of the public. Indeed, there also doesn't appear to be a clearly delineated dialogic partner for the court to exchange views with. So my own preference would be for the kind of relational analysis that I mentioned earlier. So to say, we move from monologue to relationship. And particularly, a term that I am going to put forward here is that of engagement. And engagement, according to the Cambridge Dictionary, is the fact of being involved with something, or the process of encouraging people to be interested in the work of an organization. Now, the term engagement, which I have used in a forthcoming book chapter where I also follow up on my earlier work on literacy, I think would allow us to emphasize that the number of participants involved is greater than 2, and that those participants can relate to one another in both formal, organized, but also more informal and unstructured ways. It also signals that there is no immediate reciprocity or response required. So I'm just going to put that out there, that I like the term dialogue. I'm just not quite sure whether we are already at a dialogic stage when it comes to the court's engagement or interaction with the public at large. My second observation concerns some further reflections on why courts may pursue popular support. Now, the book, I think very convincingly, suggests that they do so to protect their message and preserve a positive perspective from the public. So I agree with that, and I think that, especially for the courts under examination, this arguably seems to be the motivating rationale for their behavior. But what I would suggest is that political science research indicates that additional complementary factors may be at play. Ideational factors, for instance, could be involved, here in the form of a judicial commitment to transparency. This would suggest the dissemination of content that is likely more educational in focus, with a view to boosting the public's awareness of the work done by the court. Practically speaking, there could be a question of whether there is sufficient institutional support, in the sense of courts being well equipped to embark on PR or outreach strategies. It has also been suggested by some political scientists that strategic self-promotion might be at stake, with public engagement strategies being a promising way to promote, and not just preserve, a positive image, as well as foster public trust in judicial institutions. This would be particularly relevant in settings where courts lack widespread public backing or suffer from weak enforcement abilities. Now, I know that these are not the courts that Angioletta is focusing on in the book, but I do think that these are factors that may be relevant as we extend the analysis, as I very much think we should, to other courts in other settings. Such, in a way, strategic self-promotion strategies could then be seen as part of a broader effort to shore up support in anticipation or in the face of executive backlash or legislative displeasure at judicial rulings. A court could also be motivated to engage in alliance building or a constituency mobilization to enhance compliance with court rulings. And finally, and I've seen that domestically here in Singapore, public engagement might be spurred by a desire to ensure access to justice by explaining how procedures work and how the court functions to make sure that the courts truly operate and exist for the benefit of ordinary individuals that have claims that are worthy of vindication in court. Now, understanding the factors that entice a court to establish stronger, more direct relationship with the public matters. On the one hand, it allows us to make more sense of judicial choices when it comes to the channels used or the content produced for the benefit of the public at large. On the other hand, it allows us to better appreciate how courts relate to their wider environment and the extent to which variations in that environment may shape their behavior. In this regard, I think it will be very interesting to explore how the turn to the public taken by courts in the Global South relate to the findings put forward in this book. Let me then, as promised, end with 2 questions. And I hope that these may provide food for thought, not just for Angioletta. These are questions that I've been mulling over as well, and I hope that the audience may find it stimulating as well. So here goes. My first question is this. If courts participate in public debates about constitutional developments or legal reforms that implicate the Constitution, that is something that we may very well want them to do. So we would say if there are either pro-democratic developments or regressive developments, we may want the court to speak out about this. How should such engagement be categorized? Is this a form of protection as promoting constitutional principles and values, the ones that courts are the privileged guardians? So would we here say courts are doing something that fits with the core of their activities? Or is this straying into the territory of protection as promoting a partisan message of the courts? So when courts are asked to or feel compelled to share their views on legal developments, and it could be, for instance, a new constitutional amendment that we would say is actually pro-democratic, pro-rule of law, how would we categorize that? So I think that's my first question. My second question is this. The book suggests in its final chapter, which I think offers a very rich and helpful outlook for future research, that individual justices and court presidents in particular can play a leading role in making the most of the embrace of more openness and interaction with the public. And I fully subscribe to that. Now, if it is valuable or important to cultivate such an attitude, how, if at all, should this shape our thinking about the attributes of who would make for a good constitutional judge, as well as our understanding of the characteristics of who makes for a good judicial leader? So to be clear, I'm not advocating that a commitment to transparency and an amenability to engage with the public at large should become an eligibility criterion for the appointment of judges on the bench. But should this be something that we bear in mind as we think about who makes for a suitable candidate to sit on the court, and particularly perhaps to lead the court? Because the book, I think, very persuasively notes that a number of the initiatives that have been discussed came about at the initiative of a particular court president. So there seems to be an important personal dimension here. So with that, I would like to again convey my heartiest congratulations to Angioletta for producing what is very clearly a thought-provoking book. I could have had 6 lessons and 6 observations and 6 questions, or even more than that. This is a book, I think, that deserves to be read by constitutional scholars spread across the globe, by political scientists, by those interested in communication studies, but also by the courts themselves and all of their personnel. I look forward to the Q&A. Thank you so much.
Indeed, Maartje, thanks so much for your comments. And now I give the floor to Giorgio Repetto. Giorgio, thank you for accepting our invitation.
My personal thanks for Giuseppe for the invitation, to Angioletta and Maartje for discussing all together with friends and colleagues that I see before me here, which are connected. It's a real pleasure. So the pleasure has started in the last weeks when I started to read the book of Angioletta, and I have been thinking about how could I select the too many inputs that I had from the book. So I will do my best to contain myself and to contain the many things that I would like to emphasize, the many qualities of this book. And I already told Giuseppe, we are close friends. And so you can stop me in whichever moment if I speak too much. So the book of Angioletta has already been told, deals extensively and thoroughly with the debated topic of courts communication from both a comparative and an interdisciplinary point of view. And these are, in my view, the two defining traits of her research and what enables me to define this book somehow like a milestone. We have before us something which in my views looks like a milestone, in that the main merit of this book is the capacity to transform a group of problems, a group of questions, a group of literary and scholarly reflection into a brand new comparative constitutional law topic. This is personally the aspect that I would like to start from, since it's the main merit of the book. And this is a book that is deeply connected with the present times. I would add that this book is a sign of the times, in that it has been conceived of and written in the last years, and by no case the recent period we have explored that in Western democracy, but not only, constitution and Supreme Court's action is more and more embedded in the public sphere, and communication is part and parcel of their quest for legitimacy. The exploration put forth by Angioletta, in my view, has been able to grasp the question of legitimacy, which is a defining word of her monograph, in a highly convincing way. I've been overly convinced by the approach she chooses and by the final outcomes she offers to the reader. So I will divide my presentation into two main parts. In the first part, I will explore some general aspects which are mainly dealt with in the first part of the volume, and in particular, I've been intrigued by Angioletta's contribution as to how courts should establish communication and what constitutional courts communication is for. These are quite general aspects that help, in my view, shedding a new light into on this topic. In the first part, if I will have time, I try to dedicate my reflection to particular aspects, and in particular to some single techniques and single forms of communications. So the last preliminary remark I will spend is that my perspective moves from a comparative approach, and I try to combine the comparative approach with my experience, as Giuseppe was saying before, as a law clerk. So my perspective is originated by the second job I'm doing in these years. And so I will probably insist too much on the Italian perspective, but we had from Maartje a brilliant contribution has to the comparative perspective. So I would like to move from a perspective of the Angioletta's book, which she draws from communication studies. Maartje has already highlighted that she combines legal analysis with other disciplines. In my view, the combination of legal analysis and communication studies is one of the defining traits of this book. And I have found particularly convincing what Angioletta writes at page 18. I have to show that I read it thoroughly. When she differentiates three different aspects of courts communication, that is institutional, political, and social communication. In my view, this is one of the main inputs of the book. So the whole trajectory that Angioletta travels on in the book is guided, among others, by the need to differentiate the audiences to which the court talked to. If I move from this differentiation, I have better understood that communication studies help reveal newly established dimensions of judicial action in contemporary democracies, since this is one of the theses of the book. Communication reinforces constitutional courts' action and social and political perception of courts vis-a-vis risk of the populist rise that have been evoked before. But I would like to add to the risk of the populist rise even the risk of the juristocracy. So the need to refer to a wider communication helps even to restore the not insulated nature of constitutional courts. I mean, the juristocracy rhetoric, as in the last years, bolstered the idea that courts should coincide only with ivory towers, and the panoply of communication instruments that Angioletta highlights helps de-dramatize the more cynical aspect that the juristocracy theory somehow implies. More in general, the increasing role of courts and the increasing need for communication reveal and is related with a ghost that we should evoke. And the ghost we should evoke is the crisis of electoral democracy. When I was saying before that a book on courts communication is a sign of the times, that is related, in my view, to the need we have to explore somehow new ways in order to confer a non-political legitimacy to constitutional courts. And this is related with the problems of election. So, as I said before, the whole research of Angioletta is centered around the idea that we should differentiate the targets of the court's communication. So, if we move from the institutional communication, constitutional Supreme Courts do remain, this is my idea, they do remain judicial actors while exercising de facto, sometimes, governmental functions. We should be aware of this. We cannot hide behind a finger. This is the way Italians do express this feeling. And my impression is that we should move from the perception that the judges, according to someone, they are still the bouche de la loi. We are outside of all of this. All of this has been left behind. As of today, in Western democracy, constitutional and Supreme Courts are integral parts of the government machine from a different point of view. And so the institutional communication reflects the needs of every institution, because of being an institution, to research a legitimacy which is not support. Angioletta is overly right. And we have to establish a new way of dealing with legitimacy of Supreme Courts. Second aspect, political communication. The book of Angioletta is an excellent contribution in order to show that political communication of courts, so the communication of courts which is mainly addressed at political actors, does imply necessary partisan communication. So courts are suited for communicating to political actors while not endorsing a partisan point of view. And third part, social communication, the broadest sphere. Institutional is a narrower sphere of audience, then political, and then social. Constitutional legitimacy, as of today, is a social expectation. We should not forget that almost everywhere in Western democracy, there is a growing expectation from courts, which, as of today, they concur with political actors. I do remember what Gustavo Zagrebelsky has been writing on this point some decades ago, when he defined the Italian constitutional courts as an institution which reflects the social expectations of society. So the book of Angioletta is able to grasp these transformations and to investigate this more general transformation from the perspective of courts communication. Once we have established the different targets and the different audiences of communication, I have been inspired by the book in order to understand and to have a clearer view about what is constitutional courts communication for. So my perception, and I question if I'm right to the author of the volume, is that communication for courts are necessary in order to pursue a twofold objective, which is institutional legitimacy on the one hand, and the activation of a constitutional education, a constitutional pedagogy on the other hand. So these two main objectives go hand in hand, they work together, and they qualify the action of courts that are explored in the volume. So, as to the first part, the institutional legitimacy, Angioletta was saying before, love and hate with the press. Communication is a necessity. It is necessary in order to activate a dialogue. It's necessary in order to view the action of courts from an output perspective. And I found intriguing your reflections about the role of the press. Since communication with press, you write, should not aim at establishing a political consensus. But at the same time, you rightly insist, in my view, that the relationship with press is necessary in order to correctly vehiculate the core of the court's decision. So my impression, and I ask you whether I'm wrong or right, is that the communication of courts is somehow, with press, it's somehow a second order communication, in that courts communicate in order to leave the press the power and the autonomy to organize the constitutional message. And in so doing, the court preserve their autonomy against constitutional appropriation of political actors. So I've been convinced by this idea. A second aspect that I would like to highlight. Forms of and the intensity of communication are strictly dependent upon different institutional contexts and role played by the courts therein. So I had the idea, which has somehow shaken my certainties, and this is a positive note for the book, that wherever we have direct application procedures in courts, or we face courts of general jurisdiction like Supreme Courts, communication follows a more strictly judicial logic. That means they are more restrained. So I move from this idea, if I read your pages about, for example, the Supreme Court of the United States or the United Kingdom Supreme Court. So these judicial actors do follow a much more restrained attitude toward communication. In other cases, and quite on the contrary, judicial communication is more clearly inspired by a direct confrontation with parliaments and political actors. And this could be the example of Italy. So if so, I thought that it would be interesting to focus on communication methods and tools for supranational courts. So, which are the institutional counterparts for supranational courts? So, which are their forms of communication? We would find probably many similarities, but I think that we would find even many differences, since the main institutional counterparts are the states and not only the institutions. And this somehow modify the situation. As to constitutional pedagogy, I'm approaching the end of what I want to say. I have been deeply impressed by a quotation that I find in page 144, a quotation of Hennessy, who writes, to give rise to public opinion, the issue of general interest must be a contemporary situation with a likelihood of disagreement. So I can tell why, but I've been somehow touched by this point. I found it very centered on the question of constitutional pedagogy, and I find that it is very useful in order to understand the constitutional obsession of the relationship of Italian authors with the problem of constitutional courts communication, since that is, in my view, exactly the problem. So how can we grasp constitutional disagreement from the perspective of constitutional courts? Probably your book inspired me in this direction. So reluctance towards constitutional pedagogy of courts highlights a more general problem. Those who are overly critical about the pedagogical function of constitutional courts do probably believe that the constitutional politics and everyday politics are strongly enmeshed, are strongly interconnected. They consider probably constitutional courts as something which is intrinsic to governments, in that courts do provide unity against disagreement of party politics. So constitutional pedagogy somehow breaches the idea, and so is suspect, because constitutional courts occupies political spaces or endanger unitary performance delivered by courts. On the other hand, your view, and personally my view, is that constitutional values work on a different scale, and constitutional politics is different from everyday politics. I do run to the end, and I approach the final remarks, in that I already spent something about the quest for legitimacy. I have to highlight two aspects for which I have probably a view which is not entirely coinciding with that of Angioletta. The first one, I have to confess that I have doubts as to transparency as a value that enables the courts to communicate. So this is a complex problem. I do not have probably time for exploring my doubts, but basically, I am not sure whether courts should drive the ideal of transparency. I mean, transparency is something which, in my view, is strongly connected to political responsibility. And you are somehow not enthusiastic on transparency, but I was curious to know whether we could all imagine that the action of courts should be transparent as that of political actors. The second point that expresses, so I have to overemphasize the elements of disagreement because I do agree with almost the entire book. So the second doubt that I have is, do we have bad practices? So the countries that you explore are more or less all successful stories. So there are countries where courts do communicate more or less, but the impression that a reader gets from your book is that communication works and is necessary. So my question is, can we imagine that there are situations where an exceeding communication is an evil? So I move from a very clear example, which is the Brazilian example. As far as I know, Brazilian is an example of a bad practice. I'm not as an expert of Brazilian law, but I've been told that even the secret hearings of the Brazilian Constitutional Court are streamlined, and there are factions who support one judge or the other. I am quite sure that you share the idea that this is not a model for communication, but I was curious to know whether we can have a clear light even on the such bad practices. Last 30 seconds that I steal for what I wanted to say on the secret forms of communication. I do entirely agree with the doubts that have been expressed by Angioletta on anticipatory press releases. And as the Italian readers of constitutional justice know, in the most recent trends, in the very recent, in the last weeks and months, the Italian Constitutional Court has changed its approach in that, for example, anticipatory press releases have almost entirely disappeared, and the court has decided to publish press releases not only on great cases, but even on everyday cases. And third point, from the press releases, the name of the judge has disappeared. So the court has emphasized the collegiality of decision. I do firmly believe, and I'm not joking, but I am quite sure that this is even a sign of the book of Angioletta, and she has contributed to the disappearance of anticipatory press releases. So thank you all.
Thank you. I don't think so, but thank you.
Thanks indeed, Giorgio. Thanks so much. Okay, so now, Angioletta, would you like to react to the questions and comments, let's say, posted by the commentators, or do you want to gather the other questions from the audience?
I think I can answer those questions. So to leave to the participants the time to think if they have some remarks or for other questions.
Good.
Okay, so there are. First of all, to Maartje, to Giorgio for their insight, stimulating stimulating consideration. Thank you very much. I tried I wrote a lot of notes, so I'll try to address the many different issues they have raised. So the issue of dialogue that Maartje addressed. So is it real dialogue or not? Yes, of course, this is a formula that I use. Of course, it's a metaphor. So you are right. It's more a metaphor. It's difficult to find a word which grasps exactly the situation of whole course, because although there are many similarities, as I said, although the landscape is quite similar, of course, the individual situations have nuances, they have differences. Yes, but nonetheless, I still believe that this is a good metaphor because of course, there are some situations in which there is no real engagement, no bidirectional communication. But my impression is that although other courts do not have adopted solutions such as the trip around Italy, but nonetheless, all of them are trying to reach the people at their doorstep, as the UK Supreme Court said. So, of course, the most important solution to engage in a dialogue are these trips around the country to reach all the people where they live, the different regions, and so on. But there are many other solutions which have been adopted. For instance, the meetings with students, the meetings with citizens. When courts travel around the country in France or in Canada, they also meet a citizen. So my idea of dialogue basically comes from these meetings. I'm aware that those are public hearings across the city and across the country, but there are also other collateral initiatives that courts have also launched in connection with their travel. So I think that those are more authentic strategies of dialogic engagement with the citizen. So conversation, of course, this is not a conversation, but your remark is very insightful because I understand what you mean, because I mean, this is the ambiguity. It's emphasized the ambiguity behind all this solution. So courts are trying to pursue a more proactive approach, but at the same time, they are courts. They cannot play at the same level of citizens. So in this respect, you emphasize a very good point. All the tools I address in the book have to face this difficulty. The social media, for instance, courts engage in dialogue with the public. Nonetheless, they cannot play on the same level of citizens. They publish news, they publish posts, and their followers react to those information, to those news. But nonetheless, courts cannot play on the same level. They cannot react. So this is due to this, to the ambiguities behind all these strategies. Courts are using solutions, initiatives that have been developed in other contexts. So they are just trying to adjust themselves to this new idea of communication, but the ambiguity is evident in all the initiatives, solutions I addressed in the book. So the other point is that Maartje raised is, if I'm not wrong, is this idea of strategic self-promotion. So yes, I agree entirely with you. And that's why I selected some constitutional courts which share many similarities. I mean, I stress in the book that I selected three courts from civil law jurisdictions, three courts from common law jurisdictions, because my purpose was also to emphasize that despite the differences in the legal systems, there are many similarities. Nonetheless, I selected courts of established and long tradition, and because strategic self-promotion is risk, is a danger, and also the course that I address in the book face this challenge, this risk. But of course, this is even more prominent, it's even more evident when courts have to illustrate their role in the system of government. They have to present themselves and to to demonstrate also a change in the constitutional context. They have to demonstrate they pursue a different approach. They have to, when especially courts in the global south, they have to show that they are following the mainstream constitutional practices. So it's, in that case, strategic self-promotion it's much more evident. I don't know if I answered your question, so it says, well, sorry. In terms of instead of yes, in the last pages, I would just to add a last remark on what Maartje said. In the last part of the book, I tried to address some solutions, some proposals that court can use to face these challenges, to solve, to address the problem raised by the institutional communication. Yes, now I agree with you. The ability of the Chief Justice to adequately present the role of the court. It's a quality. It's a quality that has become very important in the last few years. So the Chief Justices are not only representatives of the courts, they play a key role in communication. And in this book, I stress the key role of many Chief Justices, starting from Canada, for instance. Most of the changes in communication are also due to the ability of Chief Justice to engage with the public, to communicate in a more effective way. So I do believe that this ability to represent the court in an effective way, to support the court also in terms of communication is a necessary quality that Chief Justice should have in the present landscape. And now I come to Giorgio remarks. So yes, I address in the book the different targets of communication. Yes, one of the main points I stress in the book is that there is it's not possible to talk about a public or the courts. There are many publics, many different publics, and courts adjust their language, adjust their communication depending on the target. And this is a challenge for the courts, because this is what usually political branches do. So it's very difficult to address different kind of audiences and to establish communication with them. And of course, it's also difficult depending on the tools, of the strategies you use. In the book, I also focus on social media as a tool to address the new generation. In the many conversations I had with the heads of communication, they told me that the target of their communication was in the last years were the young generations in the last years. They were targeting a different kind of public. So this is calls the court to new responsibilities, of course, because depending on the audiences you are addressing, of course, there are different challenges to face. But yes, I think that you are right when you suggest that the communication, the overall landscape, reflects the social expectation of society. Yes, I agree, and this is. This approach, those different approaches to different publics, the use of different languages, different tools, and different levels of technicality in their communication. This reflects this idea, this needs of the course to reach all people and all different kind of citizens. It's not possible to address the specialized audience. It's important also, for course, to address those who do not have a legal culture, and with all the consequences in terms of challenges that this approach implies. And in terms of transparency, you say that you do not agree with my idea. Yes, I understand what you mean, but in my book, I basically refer to transparency in terms of publicity of the public hearings, of the judgments, and therefore my idea of transparency is strictly related to accountability. So this is, I agree with you. Transparency is a concept that has been developed in connection with political branches. It's widely used for civil service, for instance. My idea was transparency as information on what the court have decided. So basically publicity of their public hearings. So this is what I refer to in the book. And so this transition from transparency to communication basically means that in the beginning, the purpose of the court was just to communicate their judgments, to pursue, to inform citizens in order to pursue also accountability, publicity. Now instead we have moved to communication. Transparency was implied unidirectional directional flow of information. Now instead we are in front of a bidirectional flow of information. We are moved from transparency to communication. Is this communication successful? Your second question. Are there examples of bad communication? Yes, there are. I think so. There are some bad examples also in my book. For instance, the use of social media is something that in my opinion, raises a lot of issues. I refer, for instance, to the German Constitutional Court, who closed its Instagram account in a few weeks because the courts are sometimes not able to manage those tools. So I come back to what I was saying a few minutes ago and answering Maartje's questions. Yes, nonetheless, now I would like to stress again that I selected courts of established and tradition, courts which have also which enjoy a similar level of public support, because at the same time, this is narrowly related to the means, the tools of communication they are using. And so they also, the approach they adopt, it's quite similar. They share the same concerns in terms of legitimacy. Now I've noticed that the Italian Constitutional Court has changed its approach. Unfortunately, this is not due to my book. It's not my. It's not an effect of my of my book. I'm sorry about that. I have no role in that. But I would like to stress that. The anticipatory press releases were due mostly to the fear of the Italian Constitutional Court to prevent misleading reporting. All courts share this concern for misleading reporting. Other courts have adopted other solutions to prevent misleading reporting. For instance, the German Constitutional Court has adopted the practice to meet some journalists in advance before the official release of the case in order to illustrate them the contents of the cases. Nonetheless, this solution has been criticized as well. So most of the criticism is related to those efforts of the court to prevent misleading reporting. Courts are aware that reporting is crucial. They also have to count on journalists to spread an effective message. And you are right when you said that when you stress that this relationship with the press is ambiguous. I think that those situations I illustrate in the book, the anticipatory press releases, the practice to meet journalists in order to illustrate the contents of the cases in advance, all of them demonstrate the ambiguity of this relationship and the difficulties that courts are facing when it comes to molding an accurate reporting of their cases. It's difficult, of course, because this is also due to the features of communication. News circulate at an incredible speed. I make a few examples in the book, remembering, for instance, that after 3 or 4 seconds, the cases are already available on Nexus and Westlaw, and that cases are sometimes so long that it's difficult for journalists to grasp the meaning in a few seconds. There were very interesting cases of inaccurate press reporting, which were due to the lack of cooperation from the courts. So courts are in this ambiguous situation. They have to support journalists, but at the same time, they have to preserve equal treatment among journalists, and they have to also preserve their legitimacy, of course. So I don't know if I answered all the questions, if I missed something. Anyway, you can ask if I missed something. Thank you.
Thanks indeed, Angioletta. We don't have much time, also because it's very late in Singapore. But I think that there is time for a couple of questions. So if you wanna, if someone wants to jump in, please use the virtual hand, and I give you the floor. Yeah, Camilla, please, Camilla. Let's gather the main questions. This way, Angioletta would be able to react at the end. Please, Camilla.
Okay, so good afternoon, everyone. So thank you for this presentation. It was very interesting. I have to admit that I haven't had the opportunity yet to read the book, but I will definitely put on my list because this webinar gave very useful insights. And I have a question regarding like maybe a comparison between among constitutional systems in which, so regarding the relationship or how does it changes between the court and the public in constitutional systems in which it is possible for judges to attach a concurring or a dissenting opinion to the judgment, and in systems like in Italy, in which there is no possibility and there is the judgment and that's it. And it's like a monolithical ruling without, let's say, giving the judges the opportunity to have their individual say. It has its pros and cons, of course, but like in a sensitive social issue, which would mostly trigger widespread reactions from the public. So how does it change? How does this possibility changes the relationship with the public? So I hope it was
Thank you,
clear.
Camilla. Nicola?
Thank you for the presentation. I will read the book as soon as possible. I have theoretical remarks and a more concrete question. The theoretical remarks was about the debate also that we have in United States about the function of the Supreme Court as institutional exemplar of public reason. And I think this is also very similar also in Europe, when I think also Amato, the former president of the Italian Constitutional Court, see the legitimacy of the Constitutional Court in a sort of reflective equilibrium between judgment and the public shared conviction, democratic conviction. This is useful because I think that that we have a very weird case about the admissibility of the referendum on assisted suicide, where there was an unusual press conference where for Amato said something like,
I'm laughing because in all the presentations I made, this question is recurring.
Yeah.
Nicola is no exception. So
yeah, because this was a very a weird statement by a president of Constitutional Court about how to frame the constitutional question and the constitutional legitimacy of this issue. And then I want to know about this search for legitimacy, and if this sort of public reasoning, the legitimacy by public reasoning. And the second remark was about, I remember an interview with the current president of the German Federal Constitutional Court in a podcast by the Italian Constitutional Court, where he said that he was quite skeptic about the use of social media, and he preferred the institutional way to release decisions. Then I think that also the Instagram account of the German Federal Constitutional Court was closed also after this declaration, this statement.
Yeah.
Thanks.
Okay.
thank you, Nicola. Angioletta, you have the last say.
Yeah. Thank you. Thank you for your questions. Yes, the dissenting opinion, there is a debate in the last few few months on dissenting opinion in Italy as well, because because of course the communications also is also related also to the way in which also the justices illustrate, present their own perspective, and of course this brings to the fore also the issue of dissenting opinion. I don't, anyway, nonetheless, I don't emphasize any difference among the jurisdiction I address in the book. I mean, I don't think that courts which use a dissenting opinion are more open. Maybe it's the opposite. Maybe in the United States, where the dissenting opinion is used, the court is very, very closed. So I think that sometimes this is a way for the courts to say, of course, to remind we speak only through our judgments. So if there is an effect of dissenting opinion, is a restraining effect on communication. That's my perspective. Nonetheless, I do not stress such a strong relationship. I should investigate it even more, but I don't see actually a relationship. If there is a relationship, the relationship is in terms of restraining communication. And the press conferences, the controversial press conferences on assisted suicide, yes, this of course is it's an issue related to the personality of the chief justices, which I addressed. Of course, depending on the background, depending on the personality of the chief justice, this, of course, also has effects on the communication. Of course, nonetheless, I stress in the book that the Italian Constitutional Court has a tradition of communication. Even it was one of the first courts to meet the press, to illustrate controversial cases. So it's a practice that courts have followed for many years. And now, of course, media exposure is increasing the visibility of individual justices and the visibility of the chief justices as well. And in terms of social media, yes, I agree. This is a difficult means of communication, very difficult, because it's completely different from, it doesn't fit with the kind of message that courts are transmitting, are communicating. The traditional message of the courts are judgments, and it's very difficult to summarize a judgment in a very short post. And at the same time, social media imply a reaction, imply comments, remarks from the public. When I met the heads of communication, all of them told me that the use of social media is a reason of concern because of the comments that they receive, because they cannot react, of course, because if they react, they are playing at the same level of citizens, so they have to pursue self-restraint, of course, in their communication, but at the same time, they cannot, they have to try to say something, especially in some circumstances. So that's why they are finding alternative solution to react. The Italian Constitutional Court released some press releases to express its point of view after some controversial statements in the press. So it's difficult. They cannot prohibit communication. They cannot forbid communication on social media, because otherwise they will be accused of silencing the public. But at the same time, they cannot play at as citizens in the same way as citizens do. Okay. I hope I
Brilliant.
answered your question. Thank you.
Thanks indeed. Thanks indeed. Okay, so
To you.
today we enjoyed the discussion of this very important book, the latest monograph by Angioletta Sperti,
That's a
Constitutional
seller.
Courts. Let me do, the job, right? Constitutional Courts, Media and Public Opinion, recently published by Art Publishing. Thanks so much to Angioletta, the author of this gem, and to Maartje and Giorgio for their fantastic comments. We enjoyed the discussion. Thanks indeed. It was a gift. See you soon.
Thank you. Thanks to you all. Thank you for joining.